Hi, and welcome back Inside the Law, and welcome to this special premiere episode of Inside the Law. Of course, this is the LawTube channel where we take you inside the real justice system, not just the one you may think we have if all you do is watch cable news, but the real thing. We talk about how things really work in real life. And for those of you who have been following along here, one of the topics that we've been discussing here inside the law is Georgia's open records law and how it applies to district attorneys in the state of Georgia. Of course, this was brought into the fore by attorney Ashley Merchant, who, endeavoring to get information related to her defense of one of the co-defendants in the Fannie Willis versus Donald Trump and others Fulton County racketeering case, Ashley used Georgia's open records law to learn a lot of information that she was able to use in connection with her efforts to disqualify Nathan Wade, Fannie Willis's former, special prosecutor and apparently paramour, who was an outside lawyer brought in to help prosecute this case. Ashley used the open records law to great effect, but nevertheless, Willis, in many instances, worked to stymie Ashley's efforts to prevent her from accessing these records. So let's take a look real quick at what the judge said just the other day related to Ashley's lawsuit that she filed to enforce the open records law. And when we get back from this video, we'll talk about some recent developments in Georgia law that underscore the point that prosecutors must, in fact, follow this law.
By the time those requests morphed into the subpoena that was served on Fulton County, Ms. Merchant had been educated about what it was she was asking for and how to ask for it more clearly, which again could have all been accomplished had Mr. Bond not had the Ashley Merchant rule. And so all of that is to say this: what I'm going to ask for from the merchants is a proposed order that rules in favor, or proposed judgment, I guess it would be, that rules in favor of the Merchant law firm in this action.
All right. So here's what's happened. One of the defenses that was raised by Willis through the Fulton County Attorney's Office that was representing her was they said, look, she is an officer of the judicial branch of the state of Georgia. Well, how does that make sense? Prosecutors, they're not judges. What's going on here? Well, as a matter of fact, district attorneys are constitutional officers. The state constitution in Georgia creates their office. It happens to be tucked away in the judicial branch of how the state is organized. But let's be clear. Prosecutors, whether we're talking about Willis or anybody else, even federal prosecutors, your traffic court prosecutor down at your local municipal courthouse, they are performing executive functions. The prosecution of crime is and always has been an executive function. Okay. So what the issue was, Willis was saying, look, among other things, I'm a constitutional officer, which is true. She is a constitutional officer. She's elected by the voters in her county, and the office is created by the Constitution. And she's saying that as such, and because I'm a judicial officer, I've got all this immunity. Okay. Well, that just doesn't seem to make sense. The open records law in the state of Georgia, it's a statute. It's an act passed by the legislature. And it says that state agencies and offices have to provide records to the public, records that relate to, well, anything that they're doing. And there's really without limitation except for some specific statutory exemptions. For example, you can't file an open records request and get the Atlanta Police Department to give you their case file on a pending murder investigation, for example. So there are certain types of things that the legislature says are exempt, but they have to respond to your request and cite the exemption. All right. So one of the issues raised by Willis was this particular defense, and she also tried to get Judge Krause, who you just saw there ruling for Ashley Merchant. She tried to get Judge Krause to put Ashley's lawsuit on hold until the Supreme Court of Georgia could decide the very issue of whether DAs are exempt under Georgia's open records law. Well, as it just so happens, the Prosecuting Attorneys Council of the state of Georgia, which is the state agency that advises and assists prosecutors throughout the state, they are sharing with the prosecutors throughout the entire state of Georgia the ruling that just came down this week in the case of Gonzalez versus Miller. Deborah Gonzalez is the DA over in what's called the Western Judicial Circuit. That's the circuit where Laken Riley's murder, for example, is being prosecuted. Okay. Miss Gonzalez, is described by many as, let's just call it, a Soros DA. That's what many people call her, because according to her detractors, she makes decisions on how to handle cases based on considerations that are other than traditional notions of fairness and things related to the protection of the public and victims' rights and the traditional things that prosecutors would make their decisions based upon. So lots of people are trying to find out what's going on in Deborah Gonzalez's office. One of those people is Mr. Miller. Okay. Mr. Miller had filed a lawsuit over in the Superior Court of Clark County. The district attorney asked the judge to throw out or dismiss his complaint filed pursuant to the Open Records Act. The plaintiff had said that Gonzalez individually and in her official capacity as DA, as the custodian of the records, that she violated the Open Records Act. So he filed a lawsuit just like Ashley Merchant did to enforce his request for public records. Now, in opposition to this, Gonzalez said, just like Fannie Willis said, Gonzalez said that neither she nor her office is subject to the Open Records Act. She's basically saying I'm exempt because I'm a DA. She's saying district attorneys are constitutional officers of the judicial branch. And she's also saying on top of that, that Miller, who's a tax-paying citizen, that he and his lawyer lacked what was called standing to bring an enforcement action under the Open Records Act, and that prosecutorial immunity barred Miller's suit. So she's saying I'm a prosecutor, so I'm immune. She's saying I'm in the judicial branch, so I'm immune. And she's saying that these people don't have standing, despite the fact that they're taxpayers and despite the fact that the Open Records Act exists for this very reason. She's saying they don't have standing to bring an enforcement action. So how do you enforce the Open Records Act? Well, if it's bad enough, and if the attorney general wanted to get involved, the attorney general could prosecute a prosecutor for a misdemeanor crime for violating the Open Records Act. But falling short of that, citizens can file a lawsuit to enforce their rights. So that's what they mean by enforcement action. The relevant facts regarding Mr. Miller's lawsuit: he's a citizen, a taxpayer, and he's a resident of Athens, Clark County. Pursuant to the act, Miller's lawyer, Kevin Epps, requested records regarding, quote, unprecedented staff shortages, staggering caseload, violations of crime victims' rights, failure to effectively prosecute criminal cases, and an open disregard for the laws of the state of Georgia. Okay. And if that weren't enough, on top of that, Miller is filing for a writ of mandamus. Now, a writ of mandamus is you're asking a judge basically to sign an order that orders prosecutors or other government officials to do their job. That's what a writ of mandamus is. According to Miller, Gonzalez responded to the Open Records Act request through her government email, but failed to timely produce the requested records. So he filed this lawsuit against her in her official capacity as DA and in her official capacity as custodian for the DA's office. But he also filed it in her individual capacity because he said she knowingly and willfully destroyed correspondence that he contends constitutes a public record. So how does the DA respond? Well, just like Fannie Willis did, she tried to get it all tossed out. In this case, Gonzalez filed a motion to dismiss the complaint and asked for something called a judgment on the pleadings. Well, what's that? So a judgment on the pleadings is where you ask a judge to rule with you and against the other side without a hearing. So she tried to get the judge to deny this man his day in court. She wanted him to just go ahead and lose the case without a hearing. Okay. So, with that backdrop, what did the court do? Okay. Of course, she's still arguing she's a constitutional officer of Georgia's judicial branch, right? Georgia's judicial branch. That's important because to me, it's a ridiculous argument, but well, let's just see what the court says about it. She says that because she's under the judicial branch of the state constitution, she is shielded from Miller's private lawsuit based on prosecutorial immunity and that Miller lacked the standing. All right, so on November 2nd of 2023, the court in writing denied her motion. Okay, and actually had the hearing. Okay, they did not do the judgment on the pleadings. The judge gave the man his day in court, and the trial judge sided for the citizen, Mr. Miller, citing that notably absent from her duties, her being the DA, is anything that resembles the interpretation of state law or the adjudication of civil or criminal cases. In other words, don't come to us or me as the court, Madam DA, saying that you're part of the judicial branch when I know that you're a prosecutor. You prosecute cases. You don't do anything resembling the things that a judge does. You don't do anything that resembles the interpretation of state law or the adjudication of civil or criminal cases. In fact, your job is to prosecute felonies, and that is not a judicial function. The court says that those are preeminently executive functions, since since DAs are Georgia's prosecutors for felony cases. The trial court further ruled that Gonzalez was not entitled to prosecutorial immunity from a private suit brought pursuant to the Open Records Act, and that Miller, in fact, did have standing. The Supreme Court. Now, this is the ruling that just came out this week, and it was one that Fannie Willis asked the trial judge to pause Ashley Merchant's lawsuit, waiting on this opinion. And it just so happens that the rulings from the trial court in Fulton County and the opinion on this case out of the Georgia Supreme Court happened within a day of each other. The Supreme Court says that as a matter of statutory construction, well, what is that? That means the court looks at how the law was written to basically figure out how to apply it. And they concluded that the Open Records Act does apply to DA's offices, that Gonzalez separation of powers argument, in other words, this whole I'm in the judicial branch stuff, it fails. That argument fails because DAs, as a matter of fact, exercise executive power. Of course they do. And that Miller does have constitutional standing. After all, he's exactly the person that the Open Records Act was written for. It's for members of the public, citizens, people like you and me, and anybody else who wants to know just because they're curious what their government is up to. They can file these requests, and they've got to comply with them unless there's some legal basis not to. The Open Records Act does not support the contention that Gonzalez or her office were exempt from the Open Records Act. So it says that they summarize Georgia's open records law, and it says that all public records shall, it's not a suggestion, shall be open for personal inspection, copying. The only exceptions being those things which by order of a court or by law, there are certain, like I said, there are certain exemptions written into the law. Other than those things, they've got to comply. It's not mandatory. It's not a suggestion, and they must comply. So the Open Records Act imposes a duty on agencies to either produce this information or provide access on a proper request. Again, they keep pointing out using the word duty, meaning it's not mandatory. There's a duty to disclose public records unless relieved of that duty by a specific exemption or court order. The word agency within the meaning of the Open Records Act, here they looked to another law called the Open Meetings Act to figure out whether or not the word agency includes a district attorney's office? And of course, the answer is yes. And the way they got to that answer is that the word agency is very broadly defined in the Open Meetings Act, and it refers to every state department, agency, board, bureau, office, commission, public corporation, and authority, as well as, quote, every department, agency, board, bureau, office, commission, authority, or similar body of each such county, municipal corporation, or other political subdivision of the state. And of course, they used that Open Meetings Act. They used the wording there to construe the definition of the word office in the Open Record Act, and they concluded that DA's offices are, in fact, offices as defined in the open, or as used in the Open Record Act. I'm not going to get into a whole lot in this video about the rules of statutory construction. If you're a lawyer or you're in law school and you've got an interest in this, have at it. It's a very deep and complicated subject, and it's more than we can get into here. But I will point out that they referred to something called the canon of noscitur a solis. Okay. You can Google that, research it on your own, have some fun with that. But they used this canon of statutory construction. Basically, they said, look, the legislature, the Georgia General Assembly, when they passed the open records law, they knew that they had also previously passed the open meetings law, and that presumably they knew how they defined the word office or agency in that law. And so here we're going to incorporate that into this law and determine that for purposes of the open records law, that a DA's office is within the definition of the word agency as intended by the legislature. In other words, the legislature has defined it once. They did it in the Open Meetings Act. They don't need to do it again. The same definition applies. It's common sense stuff. It makes perfectly good sense. I like this. Of course, this is not the official opinion. Remember, this is a summary based on a newsletter put out by Georgia's Prosecuting Attorneys Council. But I like the fact that the Prosecuting Attorneys Council is putting these DA's offices and in fact, this really applies to other agencies. This is good information for all agencies, not just prosecutors' offices. But they point out that the Supreme Court determined that the Constitution does not expressly state that DA's offices exercise executive power, that conclusion is inescapable. Okay. Judicial and legislative powers are expressly reserved to other governmental entities. The Constitution provides that the judicial power of the state shall be vested exclusively in the following classes of courts: magistrate courts, probate courts, juvenile courts, state courts, superior courts, a business court, court of appeals, and the Supreme Court. It doesn't mention district attorneys' offices. This is just common sense. But this is the nonsensical defense that Willis used to try to keep Ashley Merchant from having the records to which she was entitled under Georgia's open records law. So I share this with you because I felt that it's necessary to fully understand exactly what Willis was trying to do here and how she was trying to defend herself against Ashley Merchant getting to the truth. As always, I welcome your comments. Please feel free to ask any questions, leave any comments in the comments and the question below this video here once it's published. And I, of course, always please consider liking this video and subscribing here Inside the Law. I just crossed 50,000 subscribers. Thank you all very much for that. I'm very humbled by that. And now we're trying to get to 60,000. And of course, as always, your support of this channel is always appreciated using the links that appear below this video or through perhaps a super thanks if you're inclined to want to support the channel. If you think this has value or brings good information to the fore, please consider supporting this channel. But thank you, as always, for joining me here Inside the Law. And until next time, we'll see you.